I've been working with child refugee cases for now more than 30 years. And it's so what I'm going to be discussing today are the sort of practical matters that over time I've seen work with these cases. But in addition to that practice, a couple of years ago, the Law Centres Network asked me to write a report for them where they looked at, I think, 65 cases and followed them through with very, very precise care, going through the solicitor's files to try and work out what was going right and what was going wrong. And that report is entitled "Put Yourself in Our Shoes." And so it exactly reflects what Marcel just said, that consistently those children were saying, can you seek to have some empathy with our situation? And that is going to be my working theme for this submission, that really the secret to representing children is to put yourself in their shoes and have an understanding of what they are going through in terms of process, as well as what they have been through and what they fear in terms of their refugee claim. So the first thing I was going to say is just how to prepare for an interview or a conference with a child claimant. And the sorts of things that I assess for that interview, not for their claim, but for that interview, are things like these. I always try to assess their age and whether it's disputed. I always try to see what education they have, because it makes an enormous difference in terms of their ability to understand and deal with process. But I also look at how long they've been in the UK. And if they are a recent arrival, that's a very different thing to somebody who has been here over some extended period of time. And even if they have been here for a long time, I always look at their journey. I always look to see whether or not they've had a long journey to get here, whether that journey is in the back of a lorry, whether it was broken, and they had long periods in various camps across Europe, whether there's any indication of signs of abuse or signs of confinement in terms of their stay in these camps. And those are not things at this stage going to their claim, but they're going to, how do I conduct the interview? Because they are matters that impact very significantly on the capacity of the child to interact and to disclose matters with you fairly quickly. The other thing that I think is, and was borne out particularly in the put themselves in their shoes study, was how many professionals they had been involved with. And so it's just a good thing to just look and see, was this child first encountered by the police? Did the immigration people come to the police station and have a mock interview at that stage? Were they then introduced to the social worker? Was it the same social worker who actually took over their case? Were they age disputed? And if so, in that context, how many social workers have they encountered? Have they had another solicitor? How many interpreters have been involved in their cases? We counted an astonishing array of people that new arrival children were encountering in a very short space of time, and often with very little knowledge or understanding as to what their roles were. And so again, you've got to realize that you as the lawyer are just another one in a long chain. And so it is really important to have a capacity to sort of acknowledge that, and also tell the role that you're going to play. The other thing that I always have to note is whether or not they've had previous lawyers and whether or not that was poor lawyering, again, because there will be you know, sense of despair and sense of having been wronged in an earlier engagement with lawyers that you'll have to take into account. And when I've analysed and noted that information, I have ideas of how I conduct the interview in my chambers, where we have interview rooms in a basement area. I will say to our reception, this is a child who's been in the back of a lorry for some period of time. We can't have that conference downstairs. It has to be somewhere where it's a better lit room. And I would say that for trafficked children, for children who've been in any instances confined. And for all children, I think when you're in a first interview, try to seat them so that they're facing a door, so they don't feel as if they're trapped in the room, and think about where you put yourself and where you put them. So a whole series of matters. We talk in chambers about the pictures that are in our interview rooms, just because for some children who are very traumatized, to have a very vibrant and vivid colored painting can be, you know, in itself disturbing. So think about the layout and the way in which you situate yourself with that interview. The next thing is about taking their statement. And again, one of the pieces of preparation that I always do is that if I have information telling me where their village was or where their town was, I always Google it. And, you know, you can see pictures. If you've got a town, you can actually get Google Maps and see their house. You can get some real understanding of the array of amenities. You can, if you have in the some of the documentation might give the name of the school, you can see the school, so that you actually have a sense of the child's home space before you've actually seen the child. And that makes such a difference in terms of the sorts of questions that you ask. And one of the reasons for that is that in all of the studies done of the way lawyers interview, what lawyers focus on is the legal problem. So in these asylum cases, we focus on what is the reason they fled their country and what are they fearful about going back to. So that's this very narrow focus. But the reason that so many of these cases have problems of credibility is that what we forget to ask about are all of the things that they lost by leaving. I mean, it is a standing presumption in my experience over, as I said, a long period of time, is that most immigration judges work on the assumption that they had nothing to lose, that coming here was everything to gain, and that really there are effectively no ties to their home country. And I always think it's incredibly important, even if you don't put it into the statement, to have that understanding for yourself. And over the years, you see so many of these children were really traumatized to leave, really worried about their family back home. They may have been very close to siblings and they've lost contact. They may be very worried about their mothers and have lost contact. And all of those things should be included in their statements, because they give to the tribunal a sense, first of all, that they're not all the same, because if you only focus on flight, every case looks the same. If you focus on their varied backgrounds, then every case is different and looks different, and you can get a much better individualized evaluation of that case. If they have continuing contact with the family, I really want to know that, because again, a presiding presumption is that of the tribunals is that everyone is trying to pretend that they have lost contact with their family, so that they have a more a better Article 8 claim on the lack of tracing. And in fact, I think that focus of showing a complete severance with family is actually in many cases counterproductive. And you can also sometimes use a family to get information and have a better understanding of their situation. The other thing that I think when you're taking the statement is that it's very important to take on board what are the Home Office obsessions, and their obsessions are about sequencing, about numbers and about dates. And so try to get those clarified in the statements and put in there for the record to save questions on that when it comes to any sort of hearing. Now, in terms of credibility, you have a terrific document that the UNHCR put out called The Heart of the Matter, which I think should be part of the array of texts that every child immigration lawyer carries about. David Neal has also done a terrific paper on, which I think is possibly on your website or certainly available to be circulated, on the effect of mental illness on memory. I think the other point that I would say about taking the statement is that when you've got a statement and you've printed it up, go through it again and just see what other questions you ought to have asked, because in almost every case, when I receive a statement from a client and I'm having the interview, I always have loads of questions coming out of their existing statement, and so they should be something that is a checkpoint for solicitors as well. And you can see that almost every case in my submission, a lot of the worries that we have about credibility would disappear if we didn't have so many omissions in a child statement, if we didn't give proper background, if we didn't explain some things that judges are going to take work, make assumptions about. I had an Afghani case one time where, the judge assumed that he would be able to see things in his home in the middle of the night because he was working on the assumption there were street lights in a village in Afghanistan. So, I mean, a lot of those things just think into the head of the judge, and also the sort of assumptions that they bring, but also all of the things that are left out. And a very good, unfortunately, Albanian case in which those omissions were really writ large in the determination is the Upper Tribunal case of DC trafficking, 2019 case. In that case, where a young woman was indicating she had been forced into prostitution in Albania as well as here, she provided a letter from her doctor in Albania, but obviously the statements didn't indicate how she got the letter. So, that chain of a production of a witness statement is absolutely crucial, but was left out. And then her claim was entirely disbelieved because she had said that she was living with an uncle some 15 minutes away from her parents. And of course, the question asked in the hearing was, how did she manage to leave home at night and work as a prostitute when she was in a small community, when her family was so close and she was actually living with an uncle? And the answer she gave was regarded as unsustainably inaccurate. And then the other point about that case is that at the very end, there's a reference to the fact that she had a young child, and the court and the tribunal simply dismisses the child's case along with hers. And it is one of my bugbears that where you have a parent who is an asylum claimant, and there may be credibility challenges with that parent, in my submission, you would always, always, always have the child make a separate claim, because otherwise their claim and their protection is also monitored and through the claim of a mother who may be an inaccurate narrator. And a very telling example of that was in cases involving FGM recently that went both to the High Court in the Family Division and to the Court of Appeal, and you got a completely different view of the mother when she had resourcing in the family jurisdiction, but the child's claim for FGM protection was discredited completely in the immigration jurisdiction and believed in the family jurisdiction. So I think the other thing that I wanted to say was just to have a sense of what sort of protections there are in the immigration system for witnesses. And that observation about the narration in the FGM case is a really telling example, because the immigration jurisdiction is appalling, in my view, in the limited protections they provide for witnesses. You have, in the cases of AM Afghanistan in 2017 and JS and others in 2019, a discussion about whether or not in the tribunal jurisdiction they can appoint a litigation friend. And essentially the tribunal is really rather parsimonious in saying that for the most part, those over 16 don't need a litigation friend. Those between 12 and 15 need to be considered on a case-by-case basis, and then under 12 they get a litigation friend. But one of the reasons that they give for deciding that litigation friends are not needed for those middle-teen applicants is the assumption in both of those cases that those children have the assistance of a local authority. Now, we all know that a local authority pays no regard to their immigration application, plays no protective role in that application, gives no resourcing in respect of that application or that hearing, and in very many instances refuses to provide evidence themselves or to allow a foster carer to go and give evidence that may support that claim. So it seems to me that one of the things that NGOs perhaps need to do is to better inform the tribunals that the local authority is not there for these children to protect and assist and support them in litigation when they are in need of a litigation friend or they're in need of special measures, because that assumption is invoked in respect of both of those working protections. In the special measures case, which is the AM Afghanistan, they found that there was generally sufficient measures in the tribunal to provide special measures. Admittedly, in that case, they did find that there had been a basic unfairness and the miscarriage in that case, because a child who had expert evidence to show that he had moderate learning difficulties and needed particular arrangements in place in order to give evidence, that those facilities had not been made available, and therefore the appeal was successful. But when I compare it, because increasingly I find my immigration cases are going into the family jurisdiction because they do get additional protections there, and the special measures there are just so important, including that the parties agree the questions to be asked of children in advance of the hearing, so that they can have some proper preparation for it, and all sorts of ways in which the hearing room can be modified and accommodate to the sensitivity of a child. The other point that I was going to make is just to deal with those cases where you have a parent involved with a child's claim, and and I've already mentioned the significance of having a real a very, very sort of concerned look at those at the lineup for the appeal, where you've got a parent who is not a good narrator, or is a parent whose credibility is in issue. And there are cases that deal with the problems of parents being able to give evidence on behalf of a child in circumstances where their evidence in that regard is prejudicial to the child's success. There's a case called Scozzari in the European Court of Human Rights. And I think there's also another telling example and it's a very good case to know about. It's a case of B against the Secretary of State. It's 2010 EWHC at 2471, a case in a judicial review claim before His Honour Judge Pelling, sitting as a deputy. And it's a case where the case was certified on the basis that you had two parents, both of which were HIV positive. They had quite young children, and the Secretary of State's view in deciding that it had no merit at all was to say that they would be able to live with a grandmother in Malawi. And this case was absolutely shredded by Judge Pelling in judicial review. So he was saying, you know, you really need to have a proper inquiry if you are going to reach those determinations. You need to look at the age, the income, the physical and mental health, the housing circumstances of the grandmother, with a view to asking yourself whether she is a tenable alternative childcare option if both of the parents, as was claimed, become very ill on return there. And the court said it may just have been just about possible to refuse leave on general assertions that the grandmother was a potential carer or that Malawi had orphanages, if they had an appeal right. But where you certify the case and you give them no capacity for those issues to be contested, then you have done a real disservice, and the case is wholly unreasonable. And it is a very useful case in challenging the sort of generalized assumptions that Home Office too often make in their refusal letters, where they throw out a potentially safe option without any investigation or assessment as to whether or not that option is a meaningful one. Now, the last issue that I wanted to cover is the importance of the local authority in every case involving children. And I must say, in my own practice, but also in the Law Centres Network research, one of the things that really stood out were those cases where the local authority were properly engaged, where they were playing a role that was helpful, and where they provided appropriate support for children. And I take the view that increasingly that when you are working in the immigration jurisdiction, you have to have a foot now in two different jurisdictions. You have to have the capacity to undertake public law challenges to the local authorities' inertia or their positive, positively unprotective and detrimental care provided for a child. And the next thing that you have to do is to have an eye to the family jurisdiction as a jurisdiction where you may get the sort of protection that a child needs, not only to negotiate their asylum claim, but also just to be protected within the UK. there's a really rather important family case that in 2017, its reference is EWFC at 44. It's called J Child Refugees. And it is a case involving two really young Afghani boys who came here unaccompanied. And their local authority took the view that it may be appropriate for those boys to have been the subject not of a Section 20 generalized care, but of a care order. And in that case, Mr. Justice Jackson took the view that he used the case as a basis for saying that it was wholly appropriate to take care proceedings, and what are the advantages for child refugees, unaccompanied child refugees, in a care order over a Section 20 care. And in that case, he said, first of all, there is a threshold that you need to establish for a care order of the, establishing that the child has been, is otherwise subject to clear detriment and harm. And the judge held that these children who were sent away unaccompanied do meet that threshold. He said, even if the parents believed in letting them go, that it was going to be ultimately for their benefit, the fact that they went alone across Europe and got here and arrived here without any parental supervision or care meets the threshold showing that they are at risk of serious harm. So the care order was made, and the judge also spoke about what real benefits that these children get from a care order. And he said, the local authority will have parental responsibility for the children, allowing it to make and carry through decisions about care, medical treatment, education, and so forth. If the children were to leave the placement, the local authority would be under a duty to find them with whatever measures were to hand. And the local authority holding a care order would be obliged to take an active role in relation to the asylum applications. And finally, a care order would be most likely to provide the children with a plan for permanent and established family life. And considering the benefits, it will easily be seen that the advantages of a care order may particularly apply to younger children or to children with unusual or particular needs. Now, I've done several of these cases since the Re J case. I've also done adoptions since the Re J case, where child asylum seekers were adopted by their foster carers, and so they have become British. And so it is transformative having that order. And particularly when you have a very vulnerable child, and it could be an older vulnerable child, the case makes clear, but certainly when you have a much younger child, and you may have a single mother who is, say, 15 or 16, who really should be in the care system and her child in the care system. And the differences that can make in terms of the assistance and benefits one gets from the local authority is really significant, and it does allow for the development of an Article 8 claim that can be a truly compelling one at the end of the day. But I think we all know that most of the child refugees are under Section 20 care. And as I said before, one of the things that maybe we need to be much more proactive about is forcing the local authority in those circumstances where you have a special measures case, so you have a child who's really not going to be able to give proper evidence, that the local authority, in line with the assumptions of those the tribunal and the Court of Appeal, the local authority has to be proactive in assisting with special measures. The other point that I would say about local authorities, again, is something that we've seen over years, and it's such a problem, and it is the referrals that they make to solicitors. And I must say, with respect to Albanian claimants, so many of them get referred to simply a local high street solicitor or a local high street person with an immigration license, and they are given a very, very poor service indeed. So you get a case which fails the first time round, and then you have to fix it. And those are problems that arise essentially with the local authority. And it may well be that there has to be a judicial review, there has to be evidence gathered and a judicial review in terms of, with pre-action letters or something to seek to challenge that approach. Certainly, though, even when you look at what the local authority is required to do, they are required to undertake care planning. They are required to have a pathway plan and a regularly updated pathway plan. They're supposed to have a personal advisor. They're supposed to give various forms of assistance. It's worth also noting that the Children and Social Work Act 2017, Section 1, with effect from April of 2018, requires local and borough authorities, county and district councils, in respect of their corporate parenting of such children, to carry out their functions as a good parent would do. So it's a much more specific duty on local authorities under Section 20 than under the Children Act. And relevant to that good parent, they are required under the 2017 Act to designate a member of staff in maintained schools and academies who's there to promote the educational achievement of looked after and previously looked after pupils in those schools. There are things that one can challenge on. And certainly now, I think under the 2017 Act, you've got a much more precise set of obligations to a Section 20 cared for child. And you've got, certainly in the capacity to challenge under JR or simply to have a campaign to highlight and make complaints perhaps to a local politician to get them to change their practices with respect particularly to things like their referral and the way in which they deal with the immigration issues for a child. I just wanted to finish. I wanted to leave time for questioning and just say, within your backpack of resources, when you are dealing in lots of these children cases, I mean, the working document that I invoke all of the time, of course, is the UNCRC. The other document that I quote in almost every one of my skeleton arguments for a child refugee are the UNHCR guidelines for child refugees. And the reason they're important is that all of those principles that they set out in terms of what constitutes persecution, the working assumptions about relocation, the fact that you can have a child have a well-founded fear of persecution for something that wouldn't constitute that threshold for an adult. So all of those clear principles in those guidelines are really important ones to endlessly invoke, I think, because they're endlessly overlooked by the Home Office. The other the documents that I always have near to hand is the Helen Bamber Foundation on trafficking in human beings amounting to torture and other forms of mistreatment. That's just a very useful guide to the psychological issues. And it's rather an academic study, but it's also a very important and good study of Jason Pobjoy, who is a barrister, the child in international refugee law. And all of those, I think, are really important in helping to put your case forward. But I might leave it there because I want to leave time for questions.
Thank you so much, Kathryn. That's excellent. I understand that you'll be producing a paper or a list of those references, which we'll be able to share with participants at a later date. So don't worry if you haven't managed to write everything down. We do have a number of questions, so I'm just going to go through them in order, but please do write further questions in the chat and in the Q&A. This is your opportunity to pick Kathryn's brains. So I'm going to go up to the first that we have. Can you give us more details as to how a litigation friend would be appointed in the case of a 12 to 15-year-old? What evidence would the tribunal want to see before considering whether a litigation friend should be appointed?
If you look in the case, the court made reference to various matters for consideration. They certainly look to see whether the child is legally represented. Well, in your case, they would be. Whether there's an assisting parent, whether there's a local authority involved. Now, I would always indicate just how limited and poor the assistance that the local authority had given, and particularly if the local authority had evidence and wasn't disposed to provide it. Whether the applicant has any type of vulnerability, and that could be a learning difficulty, it could be a real emotional stress, it could be an ability to understand, it could be, just a sense that they may not know well what are the risks to them in their home country, so they may be at sort of a deficit of information, yeah, so I think those are the sorts of issues. And generally speaking, what you would do is write to the tribunal, indicate that you're minded to ask for the appointment of a litigation friend, and these are the issues. It may be dealt with on the papers, or it may have an interim hearing for the tribunal to hear more. But it shouldn't be a real issue to get a litigation friend. It's the most basic of protections for a child, and in every other jurisdiction just about, you would have a litigation friend. If you don't have a litigation friend, you're in something like a juvenile court, which is specifically designed for children. So it's just an extraordinary thing that the tribunal has made such a feature of it.
Another question. Do you think children claiming asylum with their parents would benefit from separate representation where there are credibility issues with the parent, or whether the same representative can cover both? And I don't know if you're able to also at the same time, as a follow-on question, asking to discuss circumstances where a child might succeed in an asylum claim where their parent would not, on the same facts.
Well, I think in a lot of cases the child would succeed where the parents wouldn't. And some of these cases, the real risk is to the child. And where the real risk is to the child, I would always have them separately represented. but I'd also have them separately represented. If on your analysis, you know, you've say spoken to a mother or a father, and you've taken the view that they're not going to be a very credible narrator. And they have, you know, may have a vested interest in hiding facts that don't reflect well on them or the care that they provided for the child. So, so very definitely in all of those cases, I would seek to have the child separately represented. You'll see in the guidance that the Home Office has put forward, even if the child is not separately represented, they can always make their own claim after the parent has been refused. I think the Home Office are a bit sceptical about those cases, so I tend to make sure that they apply in the beginning. And I think it is obviously best to get at least a separate barrister, even if it's the same solicitor. So if there's no conflict, I think the solicitor can be the same solicitor, but the child needs their own person speaking on their behalf separately, because almost always you're presenting these cases, there is a conflict, or there's at least a distinction that you are making between the parent and child that isn't easy to make if the one person is actually representing them. So I'm a great believer in children having their own claims. And the sorts of cases in which they are successful. There was a case that Steph Harrison and I did some time ago, a case called RA that was in the upper tribunal. In that case, you had a mother who had a serious mental illness, and there had been a period of time when she had been hospitalized and her child had been placed in foster care, and then was subject to a supervision order. And the Home Office at the very end of the supervision order removed her and the child without any real examination at all of her capacity to care for him. Now, they had a terrible time when they were removed, and the foster carer, the previous foster carer, got involved, got the Children's Commissioner involved, and we had a judicial review case which directed the Secretary of State to bring them both back. And then I ran, in fact, this is an Islington Law Centre claim, we ran the asylum case, and the child got asylum. And then the mother stayed on the basis of the child being at risk in her care in the home country. And so there are those cases where you don't have good enough parenting. There are cases where the child is at risk of FGM. You have the cases where there's been a trafficking issue. You have cases where the parent is, I've just had one where the parent is really hostile to the child because he's markedly effeminate, and they feel that he may be homosexual, and so as an 11-year-old he's being treated within the family very badly. So, you know, numbers of those sorts of situations can arise where you get a clear conflict. And those are also cases where local authority has got a clear role to play and may well exercise Section 20, not simply to provide support for the whole family, but to actually put the child in the care of someone else than the parents.
Okay. The next question is, what are the practical steps solicitors can take when trying to push the local authority to assist with special measures at court for the child?
Well, the first thing that I would do is to invoke those two cases, AM and JS. Because they make very clear that the local authority has got a role in supporting the child through the immigration litigation process. So that is so I think in a pre-action type letter, I would specify that is one of their obligations. And those obligations can be met, first of all, by providing information about the child's lack of capacity, for example, the child's emotional distress and so forth. but also it may mean that the local authority provides a litigation friend, and also just is supportive of the claim. It's trying to undercut this terrible rift that the Home Office has cultivated with local authorities, to try and get them to see that their assistance in any immigration case is somehow anti-government. And so I think the only way that you will get them to cooperate for some local authorities is to show them that they have a legal duty, and that they will be acting unlawfully if they don't exercise that legal duty. And you can certainly bring a case to challenge the care they are providing in terms of Section 20 when they are not fulfilling their lawful obligations.
Just two more questions, Kathryn. The next one is there a list of good solicitors, not just for Albanian young people, but for young asylum seekers from all countries?
I think those in the know certainly know who are the good solicitors, and unfortunately there's not a lot of them, and those that are there are really hard pressed. I also think that part of the issue is that you have firms that would be good if they had some assistance and perhaps some training, and there are various agencies, of which Spresser is one, to sort of try to provide that sort of training. But I think there are things to look out for. What I am always worried about, and I think it's been a very big problem in the Albanian community, but it's no less of a problem in other communities where you have a sort of rather, a reasonably large cohort of child asylum seekers, and that is the role of interpreters. And sometimes interpreters are the bigger corruption in the piece, so that it's not, you might have got a better performance out of the solicitor if the case hadn't already been corrupted by an interpreter. And I'm always a little anxious when I find that the child has been referred to a particular firm by an interpreter, and that the interpreter has come to know of them within the community. Not every case of that sort is going to be a problem, but there are certainly some interpreters in the community who take money from children and refer them to firms where essentially the interpreter is controlling the case, because no one in the firm can understand the language, and so everything is monitored through the interpreter, and that is where the distortion arises. And it's really something to look out for, I think, is not simply, do I get a good solicitor, but do I, even if I'm at a firm that may be not in the first tier of child solicitors, are they a firm that is under the control, in a sense, of an interpreter who is there for his own profit and not for the benefit of the children?
Thank you. The last question is, do you have any views on remote hearings for children?
And
I guess that might include.
Yeah, it's. I certainly think that it's. I think that it's contrary to their best interest to have a remote hearing, but at the same time, if they have been waiting a long time for the hearing, and if it's going to be a straightforward matter, it may be that I would agree to it taking place. I think it is a case-by-case analysis, but it would have to be. I mean, I've just done a bail hearing for a child where he wasn't even part of it, and I was on the telephone to the judge, so I couldn't even see the judge's expression. I think those cases, if it hadn't been bail and he wasn't so desperate to get out of prison, it would have been a hearing that you would challenge on the basis that it was simply unfair. But I think if there is to be a Zoom hearing, then I think that they need to have, you know, you need to have a lot of assistance. So the better way in which those hearings are run is where the child comes into the solicitor's office and is there with a solicitor. So at least they're not in a pokey room somewhere, sometimes on computers that are not particularly reliable. So I think that has to have some support mechanism for the child in those hearings. And with all these things, it may well be that the child's case is not one that is urgent. But if the child is in a terrible state and is fretting badly over the case outcome, and if it's a case that you know, substantially can be dealt with on you know, almost a paper application, and there isn't a great deal of cross-examination, then I do think that that sort of case can properly go to a remote hearing. You know, the wait is absolutely terrible for young people, and you know, then it's not as if they're here in a situation where they can necessarily benefit from the stay. And so it's really something that I think one has to address, is just the time taken to get from start to finish of these asylum cases.